and various governmental technologies such as census categorization, invented histories and traditions, ceremonies, the educational system, in order to exclude and include in racially ordered terms. In summer 2003, letters began arriving, or being issued by the Department of Justice to migrant parents who had applied for residency on the basis of the 1990 Padugiono Supreme Court ruling that migrant parents have the right to remain in Ireland to provide, as I said, care and company to their Irish citizen child. However, in 2003, following the Loben Osayande case, this process was withdrawn when the government panicked about rising number of immigrants. Now, it's interesting and it's worth recalling what the Supreme Court actually said in the 2003 Loben Osayande case, demonstrating the law is a central governmental technology of the racial state. I know you think you're all very independent, but I would suggest to you that the law is a central technology of the racial state. The judgment by the then Chief Justice, Ronan Keane, upheld the rights of the state by insisting, and I quote, the inherent power of Ireland as a sovereign state to expel and deport non-nationals. He was employing a socio-political rather than legal argument by saying that while the Padugiono ruling was given at a time when immigration was low, now the state could not be expected to disregard the problems which an increased volume of immigration inevitably created. And he was upholding what Goldberg called control in the face of the anarchic, order in the face of disorder. And he ruled that the state was entitled to take the view that an orderly system of dealing with immigration and asylum application should not be undermined by persons seeking to take advantage. So, the current Chief Justice, Susan Denham, added a new interesting category of constructive deportation. She said, it does not follow from the rights of citizenship and residency of a minor child that the child is entitled to the company, society, and care of his parents in Ireland. If the common good requires it, she added, the minister has the right to terminate the residence in Ireland of non-national parents of Irish citizens, leading to either the breakup of the family or the constructive deportation of the child citizen. Very interesting kind of legal and ethical and moral dilemmas here. In the wake of the LNO ruling, 11,500 migrant parents of Irish citizen children became candidates for deportation as of July 2003. Resulting from the initiative by Akidwa, which is the African and Migrants Women Network, we established the Coalition Against Deportation of Irish Children. It was called CADIC, and basically we campaigned against this deportation. For almost 2 years, however, the Minister for Justice, Michael McDowell, was unwilling to reverse his decision or recognize en masse migrant parents of Irish citizen children who had lawfully applied for residency. Interestingly enough, among the 341 people deported between 2002 and February 2005, there were at least 20 citizen children. But the minister argued they were voluntarily taken out of the country by their deported parents. In reply to a door question in February 2005, he said that these figures were infinitesimal compared to what was now 16,000 migrant parents of Irish citizens. And they give the lie to the suggestion that I'm busy deporting these people on a wholesale basis. In 2004, having, as it transpired temporarily, closed the route to residency to migrant parents of citizen children, the Irish state held a referendum aimed to reverse the jus soli citizenship access since 1922 and make blood and heredity the basis of Irish citizenship. The government's argument focuses two things. First of all, to preserve the integrity of Irish citizenship and fall in line with the rest of the EU. However, the successful case taken by Mrs. Chen, if anybody remembers, a Chinese national who lived in the UK and who chose to have a baby in Northern Ireland so that she can secure EU citizenship, leads me to argue that the racial state of Ireland was motivated by a perceived obligation by a clientelist Irish Republic towards the integrity of racist immigration laws in Britain and the EU. Now, I'm kind of putting lots of ideas there, and maybe it's too much, but stop me if I'm getting too complicated. The pre-referendum debate exposed, in my mind, two legal contradictions. The first is between citizenship and nation. According to the amended Article 2, of the Constitution as part of the Good Friday Agreement, anybody born on the island of Ireland was entitled to be part of the Irish nation. And this right was also accorded, together with the right of citizenship, to people of Irish heritage who don't reside here. The 2004 constitutional amendment meant that the people born in the island of Ireland are still members of the Irish nation, but they don't have the right to Irish citizenship. This is quite an interesting legal conundrum. The second contradiction is between two constitutional entities. One is the family, and the other one is the nation. The family is termed in Article 41(1)(1) as a natural, primary, and fundamental unit group of society. But William Binchy wrote in the Irish Times at the time that the constitutional integrity of the family was never intended to have exclusive birth connections to Ireland. Now, throughout the pre-referendum debates, it was migrant women who allegedly were arriving at the last stage of pregnancy to intentionally mother the next generation of Irish citizens, so as to gain residency for themselves, who were highlighted. They were considered, therefore, rendered this way as illegal immigrants. Although the minister claimed that the masters of Dublin Maternity Hospital begged him to do something about the spiraling numbers of non-national birth, a 2004 report by Dervla King for the Children's Rights Alliance found that it was not, and I quote her, not possible to demonstrate that the increase in birth to non-national, so-called non-national women could be attributed to the fact that their children were entitled to citizenship. That's a few figures that she gave. There was no statistic to vindicate the government's claim that a very large number of non-EU nationals were coming to Ireland with the sole purpose of giving birth. There was no data available from the Dublin maternity hospitals relating to the residency status of women who presented themselves for delivery, because many of these non-national births were to women who were labor migrants, spouses of EU nationals, there were tourists, there were students. Thirdly, it was not possible to identify the number of women who arrived in the country shortly before giving birth. There were no statistics collected as to the nationality of the fathers. Then statistics from the three Dublin maternity hospitals showed that the total number of non-EU women arriving unannounced at the late stage of pregnancy in 2003 was 548, which were just 2.4% of the total number of births in the three hospitals. At the same time, 174 Irish women also arrived unannounced in the late stage of pregnancy, some of them from counties outside of Dublin. And finally, contrary to the government's argument that a large number of asylum seekers were pregnant on arrival, now, although the proportion of pregnant women applying for asylum remained constant between 2002 and 2003, which was 58%, the actual number decreased by 60%. So, it's complicated figures, but actually puts the lie to the argument that the maternity hospitals were packed to the brim with non-national women giving birth intentionally in order to gain citizenship and residency. But the impact of the citizenship referendum on migrant mothers was huge. I want to quote Ebun Akpoveta. She said many women, particularly of African descent, who didn't use contraceptives, all began to use the 3-year implant and the 5-year coil. And this enforced sterilization actually worked, as it accomplished the state's purpose to reduce birth from non-EEA women, even if only temporarily. The long-term effect is that many African women who were forced to delay giving birth ended up having children in their 40s, which obviously increases the risk to the health of both the child and the mother. After the referendum was passed, with a large majority, remember 79.14% of the population were persuaded by the government argument that we have to preserve the integrity of Irish citizenship. Some 18,000 migrant parents were permitted to reapply for residency, although without right to family reunification. Again, a huge problem. Again, Ebun. The first impact was on families. Immediately after the law was passed, there was segregation and inequality within the family unit, as siblings had different status and rights in the state. Furthermore, she says, after the referendum, the Irish-born child, or IBC category, the state created allowed it to punish, denigrate, and stigmatize those in this category. The residency status that were granted was so tenuous that when they needed to have it renewed, they had to take the children to the GNIB, the Garda National Immigration Bureau, to be signed and identified. And most times it meant taking children out of school, and sometimes with the long queues, they had to take children out of school for 2 days. 2 minutes, wow. So I would like to argue that the Sydney referendum was a crucial turning point in the history of Irish racism, state racism, in which citizens were differentiated from non-citizens, and children born in Ireland were differentiated from so-called Irish-born children. I mean, all children born in Ireland are Irish-born children. It didn't quite work, but because the number of so-called non-national people here, in fact, trebled in the last 10 years. But I want to just briefly say something, if I may, about the direct provision system. And I'd like to say, and you know about it in inequalities and so on and so forth, but it creates a state of deportability because it enables the state to deport people as and when it sees fit. And this comes akin to what Ronit said, the inherent power of the state, the sovereign state, to expel or deport non-nationals. However, it's interesting that this state of deportability creates a state of non-deportability because many people cannot be deported for human rights convention reasons, for cost, and so on and so forth. So you have lots of people still in the direct provision system due to deportation, but unable to be deported. To conclude, I'd like just to bring the notion of race back into the equation. Because what is happening here, the work of the racial state, on the one hand, disavows the existence of race and racism. After all, we're all anti-racist now. And what another scholar called raciocracy. Because basically, race is part and parcel of democracy. Speaking about racism tends to limit it to fascist regime, Nazi Germany, apartheid South Africa, and so on and so forth. But it doesn't recognize that this is a regime. This is a performance. Race is something we do. It's not something that just is there. And therefore, even in extreme cases, which are held up as exemplary of race, such as apartheid, race is ultimately about the governance, about the actual makeup of the state. And racial rule serves to extend the rule of law, not simply to supplant it. And as I say, the Sydney referendum was a major, crucial turning point in consolidating Ireland as a racial state, in which citizens are differentiated from non-citizens. But just finally, as an activist, I'd like to say one more sentence. Recently, they've been called to reform the direct provision system and to ensure that deportation are done in a humane manner. But this simply wouldn't do, because although legal, these measures are not moral. And we're speaking here about ethics and morality. Now, Nazism at the time was also legal, so was apartheid. This is legal. We're working to a law, but we're actually working to an immoral type of law. And therefore, I would suggest that the only solution from where I stand is to close all direct provision hostels, let the people become part of Irish society, and to end all deportation. Nothing else will do. Thank you.
Thank you very much, Ronit. Our third speaker is our colleague Femi Daniyan, and Femi, as you may be aware, works in the area of employment law, immigration law, refugee succession and family law. He also has a Master of Arts degree in International Relations from Dublin City University, and he will address the topic of ethical challenges in immigration and asylum practice, and he has precisely 15 minutes within which to do so.